Good. Thank you, Stephanie, for your welcome to country. And thank you for the invitation to speak. I'd like to dedicate my speech to the memory of Heather Goodall. Richard has asked me to situate the current practice of native title in a broader intellectual and historical context. And I'm going to take 50 minutes to do that, so I thank you in advance for your patience. And I better unscrew a bottle of water. Let me begin by sketching the context in very broad terms. By the Second World War, anthropological and linguistic study had established that Indigenous Australia was a distinct civilisation, albeit a disappearing one. Then, in the last quarter of the 20th century, we revised our account of Australian history so that we made that civilisation's colonial subjugation central to the national narrative. Coinciding with that historiographic revolution, there were two others. One changed our demographic conception of Indigenous Australia. Indigenous Australia was not dying out, but proliferating, we discovered. This revised demographic picture was partly an effect of the official redefinition of indigeneity. Then in 1991, we made an important change in our civic discourse, adopting the theme reconciliation. Now, if you are an Australian, you are understood to be either an Indigenous or a non-Indigenous Australian. That binarisation of Australian is now axiomatic in our public culture. In short, by the turn of the 21st century, Indigenous Australia had been re-established as an object of knowledge and of government. That object, Indigenous Australia, is both self-representing and represented by others in a multitude of representational practices. How we think about Indigenous Australia, how we think about Indigenous Australia has been affected by the transition from assimilation to self-determination. Assimilation was associated with the view that Indigenous Australian society was in terminal collapse, and that the role of government was to facilitate that collapse and to enable Indigenous Australians as individuals and households to become equal members of Australian society. Self-determination is associated with the view that Indigenous society is not collapsing but persisting, and that Indigenous Australians' persistence is not pathological but adaptive, to be solicited and supported. Self-determination programs thus seek to identify what features of Indigenous society are productive in the sense of enabling Indigenous Australians to engage more willingly and happily with Australian society and to flourish as themselves. We can think of both assimilation and self-determination as modes of what Foucault calls governmentality. That is, the practices of assimilation and self-determination require knowledge of Indigenous society and culture, and they generate knowledge about Indigenous society and culture. There are four trajectories in the transition from assimilation to self-determination that I wish to describe. Firstly, there's the creation of the Indigenous land and sea estate. Public policy and law have created an Indigenous land and sea estate, which you know because you helped to make that happen. South Australia initiated this project with legislation in 1966. Governments took further steps in the 1976 Northern Territory Land Rights Act and in the 1993 Native Title Act. Although the literature on the Indigenous land and sea estate does not include a single precise definition of what it includes, there is no doubt that the Indigenous land and sea estate will soon comprise well over half Australia's landmass and thousands of square kilometres of sea below the high water mark. The second trajectory is the authorisation of the Indigenous sector. Around 1970, innovative policy thinkers postulated that governments should address Indigenous Australians as groups, not only as individual citizens. In 1976 and again in 2002, governments legislated to enable Indigenous Australians to form corporations that would perform a variety of public functions, including holding native title. They would be funded by governments to do so. Third trajectory, recognising a self-identified Indigenous population. In the 1966 census, the Commonwealth Bureau of Census and Statistics achieved full administrative coverage of the continent for the first time. But the flaw in the 1966 enumeration was the unresolved definition of the people of mixed descent. For reasons both technical and political, in the 1971 census, the Bureau changed the race question in a way that enabled Indigenous identified people of mixed descent to be included in the Indigenous population. And fourthly, the pursuit of constitutional recognition. In 1967, advocates of policy reform persuaded the voters that the national government must take more responsibility for Aboriginal policy and to have the power to override laws passed by a state government. Paradoxically, this gesture of 1967 constitutional recognition required the removal, not the addition, of words referring to Aboriginal natives. Adding words about Indigenous Australians to the Constitution became the next reforming step. In 1988, the Bicentennial Constitutional Convention recommended certain terms of recognition. In 1995, ATSIC proposed constitutional recognition. In 1999, the Howard government suggested certain words of recognition, but his words were not accepted by the electorate. In 2012, the Gillard government's expert panel proposed certain words of recognition. In 2017, the Uluru Convention proposed the voice as the form that constitutional recognition should take. And in 2023, by a 60-40 vote, Australians rejected that form of recognition. These are the four trajectories that Australia has followed in its post-assimilation quest for social justice: the Indigenous land and sea estate, the Indigenous sector, the self-identified Indigenous population, and the quest for terms of Indigenous constitutional recognition. I'll refer to them as Australia's four social justice trajectories. Now let me make four remarks about these four trajectories. First, while all four of them rest on an understanding of Indigenous culture as resilient and governmentally productive rather than as degenerating and rebarbative, they use different technologies of representation. Different disciplines are involved. The knowledge of Indigenous Australia is not an intellectually unified project. The relationships between the different representations of Indigenous Australia are loose and contingent. Second point, to evaluate the four trajectories as successful or unsuccessful is not a straightforward matter. Perhaps the most obviously unsuccessful of the four trajectories is constitutional recognition. The 60% no vote is still ringing in our ears. And even the formerly celebrated 1967 amendments have become problematic since the High Court ruled in 2000 that the Commonwealth may lawfully use the race power that it acquired in 1967 to diminish Indigenous interests. If there is a success story that can be told about the trajectory of constitutional recognition, it is the one that Dylan Leno tells in his 2018 book, Constitutional Recognition, about the potency of such quasi-constitutional instruments as the Racial Discrimination Act. Perhaps the most obviously successful of the four trajectories is the formation of the Indigenous land and sea estate. That estate is politically safe in the sense that, as far as I am aware, no significant political actor in Australia is trying to make an issue of this massive Indigenous repossession. Critics of the native title system nonetheless point to its weaknesses in the rights conferred by title and in the capacity of the Indigenous owners to make something of those rights. And I've just recently read an essay making that point by Nolan Hunter. Third, these four social justice trajectories attract different amounts of attention from the mass media and thus from the politically engaged public. The trajectory that has attracted most attention recently is the one concerned with constitutional recognition. In contrast with the public attention given to constitutional recognition, there continues to be little public and media attention paid to the native title system. This was brought home to me when I read the Australian Law Reform Commission's 2024 issues paper, Review of the Future Acts Regime. Footnotes 125 to 140 in that paper list many reports since the late 1990s that contain suggestions for reforming the native title system. I had no idea that this commentary is so extensive. Also mentioned in these voluminous footnotes are some unlegislated bills of reform for the Native Title Act. Footnotes 125 to 140 in that paper constitute an archive of esoteric debate about how to work the native title system. While Australians have been noisily engaged in a debate about the possible forms of constitutional recognition, there has been a much less noticed debate about the equity of the native title system. The lack of party politicking and media reporting about the virtues and defects of the native title system is due partly to the fact that the practice of native title is technically complex, as you would know better than me. But the other reason why debate about constitutional recognition has overshadowed debate about the equity of the native title system is that the Howard government's 1998 amendments assured the wider public that in his government's reforms of the native title system, the national interest and the Indigenous interest were at last reconciled, thus seeming to fulfil the moral promise of the High Court judgment in Mabo No. 2. My fourth remark about the four social justice trajectories is that we have created two distinguishable idioms for thinking about Indigenous Australia as an object of knowledge. The two idioms are the population idiom and the people idiom. I attempted to describe these two idioms in my 2012 book, Rethinking Social Justice, but here is a brief summary of the point. When we think about Indigenous Australia in the population idiom, we turn to the immense body of statistics about Indigenous Australians that governments have created since 1971. In the population social imaginary, Indigenous Australia is made up of individuals and households whose social characteristics can be described quantitatively. We can compare the Indigenous population and the non-Indigenous population in respect of a large number of variables. The Productivity Commission chooses certain variables and their comparison is the basis for the biennial Closing the Gap reports. Thus, the population imaginary encourages us to conceive of social justice in a certain way. Reconciliation is imaginable as achieving the identical socio-economic profile of two subsets of the total Australian population. The statistical equivalence of Indigenous with non-Indigenous populations, closing the quantified gaps between them. When we think of Indigenous Australians in the idiom of peoplehood, we draw on other kinds of knowledge created by humanities and social science disciplines, such as archaeology, anthropology, cultural studies, linguistics, musicology, history, political science, and sociology. These disciplines document the holistic forms of Indigenous society, the language communities, the clans, the bands, the corporations, the First Nations, and their worldviews. We are using the people idiom when we narrate Indigenous collective agency moving through time as peoples colonised and recovering from colonisation by asserting their distinct rights as Indigenous. The people idiom enables us to imagine Indigenous Australia as a political subject and political object, capable of forming relationships with other political subjects and objects. Thus, the peoplehood idiom enables us to think about social justice by reference to relationships between politico-legal collectives. The people idiom is mobilised when we use terms such as sovereignty, treaty, First Nation. In Australian political discourse, both the people idiom and the population idiom are prolifically present, Advocates of Indigenous interests draw on both idioms. We use both, and we do not have to choose one and reject the other. But we need to keep in mind that in drawing on both, we mobilise two significantly different models of equality. Mention of the widely shared value equality brings me to the third part of my address. What does the 60-40 triumph of the no vote signify? Did that defeat not confirm the thesis that, in its fundamental charter as a settler colony, Australia continues to erase the Indigenous presence? Did not Australians refuse to correct the Founding Fathers' assumption of Indigenous political absence when they were given the chance to add, that is, when we were given the chance to add Indigenous Australia to the compact that federated the 6 settler colonies? As early as 1995, ATSIC was emboldened by the positive trends in Indigenous affairs, not least the Native Title Act itself, to call for Indigenous Australia to be constitutionally recognised. In 2017, the Uluru Statement specified the form that constitutional recognition should take: a constitutional guarantee of representation of the Indigenous people of Australia to the executive and to Parliament. Australia's refusal of that request would seem to confirm the thesis that Australia is so constituted as to deny Indigenous peoplehood. In post-mortems, the racism of the No campaign is a prominent explanation. I agree that elements of the No campaign appealed to Australian racism. However, I want to dwell on another feature of the No campaign: its appeal to the values of unity and equality. Politically progressive Australians are strongly drawn to a characterisation of Australian society as deeply racist, and they too easily represent racism as the best explanation of the victory of the no vote. For example, in the Search Foundation booklet After the Referendum, published in October 2024, we read the following words: 97% of Australians are non-Indigenous, and there is no question that racism is an embedded feature of Australian society that was alive and kicking hard in the campaign for the First Nations voice to Parliament. The No campaign was underpinned and amplified by the colonialist mindset, ignorance and racist narratives that dominate Australian mainstream culture. End of quote. The Voice debate attracted a huge amount of public opinion research, but pollsters rarely asked people whether they agreed or disagreed with overtly racist views. However, they did ask questions that uncovered certain differences between yes and no voters in their views about Australian history, contemporary society, and the responsibility of governments. And I just want to show you some of those public opinion results. I'll read them out. A higher proportion of no voters than yes voters affirm that colonisation has, on the whole, benefited Indigenous Australians. A higher proportion of no voters than yes voters deny that colonisation has caused intergenerational trauma among Indigenous Australians. A lower proportion of no voters than yes voters believe that Indigenous disadvantage is systemic and the result of Australia's colonial history. A higher proportion of no voters and yes voters believe that discrimination against white people has become as big a problem as discrimination against non-white people. A higher proportion of no voters than yes voters support the view that Indigenous Australians cause their own disadvantage, and they agree that if they tried harder, they would be just as well off as non-Indigenous Australians. A higher proportion of yes voters than no voters said that government help had not gone far enough. Now, some social scientists would agree, and perhaps you do too, that the propositions that attract a higher proportion of no voters than yes voters are manifestations of what is called covert racism. However, let us pause to note the way that what some call covert racism may also at times draw on respect for the value of equality. Consider the following item offered by one pollster. As the first Australians, Aboriginal and Torres Strait Islander people should have special cultural protection that other groups don't have. Only 50% of those responding agreed, and there was a stark difference between the yes voters, 79% agreeing, and no voters, only 31%. No voters' rejection of special cultural protection that other groups don't have can be seen as covert racism. But the no voters' rejection could also be read as their affirmation of equality of entitlement among groups, to use the term in the question, groups who need cultural protection. The Indigenous voice to Executive and Parliament was also represented by the No campaign as something special, a means of representation that other groups don't have. I suggest that many who voted no were declaring their respect for equality understood in a certain way, equality as sameness of entitlement. Let us pursue my suggestion that to vote no was to affirm equality. I suggest that one important ideological dimension of the yes-no contest was that it was a contest between two widely upheld but competing understandings of equality. The affirmation of the simple equality of all Australians triumphed over a more complex idea of equality. The more complex idea of equality requires belief that Indigenous Australians, as a colonised people, have a distinct right to representation. The triumph of simple over complex equality raises two questions. For me, why was simple equality the more popular notion of equality in Australia? Why is it? And secondly, can the idea of simple equality ever be mobilised in Indigenous people's interests? Let me deal briefly with this second question, but I'll come back to it later. The idea of simple equality has been central to one of Megan Davis's political projects, her championing of the distinct interests of Indigenous women. In her advocacy of Indigenous representation, Professor Davis has sought guarantees of equality of representation of men and women in Indigenous political institutions. She has recently reiterated her argument that equal representation of the sexes is needed in order to make visible that women's interests differ from men's. This simple equality idea has no political The simple political ideal, I conclude, has no intrinsic political value. The political significance of the idea of simple equality depends on the context of its mobilisation. Why was the idea of simple equality of entitlement the more popular of the two notions of equality represented in the referendum? Equality as sameness of entitlement has been promoted as a binding value of Australia's multicultural society. I was struck by the words of the former Liberal MP Michael Sukkar in the parliamentary debate about the referendum bill in April 2023. Sukkar acknowledged one of Labor's main arguments for voting yes, that Aboriginal people preceded the British colonists by 60,000 years. He then said that for his family, migrated from Lebanon, it didn't matter if your family went back to the First Fleet, or whether your family went back 60,000 years, or whether your family arrived a couple of years ago and were at last night's citizenship ceremony. The minute you were an Australian citizen, you were in every single way equal. There was no grading. There was no different rights or different rules for one or the other. Sukkar did not dispute or disrespect Indigenous Australia's longevity, but he denied that this longevity has any moral, legal or political significance. The political meaning of Indigenous longevity depends on how it is framed. For Sukkar, it was an archaeological truth, but it had no moral, political or legal significance. That something so dear to the yes side could be framed as true but irrelevant has implications for those who promote truth-telling as a progressive political intervention. In the version of multicultural Australia that we get from people such as Michael Sukkar, it is not necessary to dispute that Indigenous Australians are a colonised people. It is not necessary to deny that they have been badly treated in the past. One can concede the truth of that critical history while refusing to give these awful facts of the colonial past any moral, legal or political significance in pondering what Australians must do next. The suffering narrative of Indigenous peoplehood, like the longevity narrative of Indigenous peoplehood, has no intrinsic moral, legal or political significance. The yes side of the referendum debate asserted that Indigenous Australians' unique history does matter legally, politically and morally. Are not Indigenous Australians unique among the peoples of Australia because they are the colonised people? Are they not uniquely entitled to unique forms of redress? The referendum demonstrated that Australians differ in the way that they answer these questions. If the no vote asserted the wide commitment to formal equivalence of entitlement, we should not despair. In certain contexts, the simple idea of equality can be the basis of Indigenous demands. In 1967, the campaign for the yes vote argued that there was no good reason for treating Indigenous Australians as less entitled to be counted and to be subject as a race to federal legislation. The yes vote in 1967 affirmed that Indigenous Australians are entitled to inclusion in a community of equals. The 1967 amendments erased the words Aboriginal natives and Aborigines from the text of the Constitution. In one narrative of Australia's history, it was this erasure of those words that assured Indigenous and non-Indigenous equality. In that way of understanding what was good about the big yes vote in 1967, the Voice proposal was a reversal of 1967's popular and admirable affirmation of equality and unity. That many no voters in 2023 may have been affirming simple equality is consistent with another significant fact about the 2023 referendum. Most Labor voting electorates voted against the constitutional referendum, the constitutional entrenchment of the voice. In 2022 election, Labor won 78 of 151 seats in the House of Representatives. In the 2023 referendum, 57 of these 78 seats voted no. And in the 2025 election, 52 of these no-voting electoral divisions continued to choose a Labor candidate to represent them. If many voters are both ALP voters and voters for no, then it may be because a simple idea of equality underpins both choices. The 2023 referendum proved the dominance of the simple idea of equality in Australian political culture. Since most Labor electorates and most Labor voters voted no in 2023, I doubt that Labor can be relied upon to champion the idea that Indigenous Australians have distinct rights. The Keating government affirmed the distinct rights of native title in 1993, to be sure, giving legislative expression to the High Court's recognition of native title. However, the parliamentary party has not internalised the concept of distinct Indigenous rights as a fundamental value. Although ALP leaders urged us to vote yes, speakers in the parliamentary debate did not argue as the Uluru Statement argued. Labor MPs did not evoke Indigenous Australians as a colonised but still sovereign people entitled to their own distinct representative voice. The three arguments for yes repeatedly presented by ALP speakers in the 2023 debate on the bill were that Indigenous Australians, having lived in Australia for 65,000 years, were the first Australians and so should be recognised in the nation's defining legal document, the Constitution. Secondly, that it would be ungracious to Indigenous Australians to refuse what they had collectively asked for in the Uluru Statement from the Heart. Thirdly, that to deliver policy advice through the voice was essential if the socio-economic gaps between Indigenous and non-Indigenous Australians are to be closed. That is, the ALP shied away from referring to Indigenous Australians as a colonised people whose colonised status under international law entitled them to distinct representation. The Rudd government endorsed the United Nations Declaration on the Rights of Indigenous Peoples in 2009. However, Labor has so far not taken up recommendations for the systematic implementation of the UNDRIP as a binding code of Indigenous rights. Labor, at least on the national political level, currently feels more comfortable on the ideological ground that it is long shared with the coalition, the former coalition. In the post-referendum, yes, this was written last week. In the post-referendum moment, both government and opposition are focused on closing the socio-economic gaps. That is, they have returned to the Howard government's elevation of practical reconciliation above any other meaning of reconciliation. While gestures honouring Indigenous peoplehood remain in place, social justice is assumed to be statistical equality between two populations. Neither side of federal politics seeks social justice as a political settlement between Australia and Indigenous Australians as peoples, with the possible exception of Victoria. I'd be interested if people want to comment on Victoria in discussion. Now, I've painted a rather gloomy picture there, but I want to look for the positives. There is great political potential for Indigenous Australians in the widely supported idea of simple equality, I believe. This was demonstrated when the Federal Court and then the High Court ruled in the recent Yunupingu Native Title compensation case that Section 51(31) of the Australian Constitution applies to the Commonwealth's extinguishment of native title. The judgment's reasoning included reaffirming that the plaintiff, a native title holder, is a property-owning citizen. In some contexts, the idea of simple equality has teeth. The idea that Indigenous Australians are equal to other Australians in their citizenship rights was once associated in the assimilation era with the idea that their Indigenous heritage was irrelevant to their entitlement and indeed an obstacle to it, an obstacle of diminishing strength. It is now an orthodoxy of government that indigeneity is not disappearing and that it is a productive object of governmental knowledge. Indeed, as an object of knowledge and power, indigeneity is proliferating. In the final part of my address, I want to turn to the ways that Indigenous Australia is represented in policy-relevant social sciences that are directed at achieving social justice of the kind of the closing the gap kind. I'm going to suggest some caution about a progressive habit of thought in which Indigenous Australians are distinguished, which distinguishes Indigenous Australians from other Australians in a certain way. I want to advocate that we give more room to the thought that Indigenous interests might sometimes be served by accentuating ways in which they are the same as other Australians in their entitlements, rather than ways that they are collectively different. Here I acknowledge that I am following an invitation from Noel Pearson's third Boyer lecture in 2022. The lecture was called A Job Guarantee for the Bottom 1 Million. What piqued my interest in this lecture was not so much the job guarantee idea, though that's well worth discussing, but Pearson's presentation of a new object of governmental knowledge, the bottom 1 million. The bottom 1 million would be made up of Indigenous and non-Indigenous Australians, defined by their poverty. Pearson's bottom 1 million category invites us to explore the possibility that policies for improving the lives of Indigenous Australians may sometimes be the same policies as those that are designed to improve the lives of non-Indigenous Australians. For example, investment in public education. This is an example some of you in this room have heard me refer to before. According to the Australian Education Union, 82% of economically disadvantaged students, 83% of Aboriginal and Torres Strait Islander students, 67% of students with disability and 68% of children from non-English speaking backgrounds attend public schools. That is, when public education is under-resourced, it harms more than 4 out of 5 Indigenous children and other categories of children. In pointing this out, I could now make an ideological choice and say that underinvestment in public education is an example of systemic racism. To say this would be to highlight that underinvestment in public education harms Indigenous Australians. True, but it's an incomplete statement of the facts. If we choose to highlight the harm to Indigenous Australians, we are following a certain political analytic that distinguishes Indigenous Australians as victims of bad policy. I'm wary of our tendency to do that, and I will conclude this lecture by explaining my reservations. The idea that Indigenous Australians are a colonised people with rights rooted in pre-colonial custom is given legal force in the native title system. But the moral and political appeal of the idea that Indigenous Australians have rights as colonised people has found expression in another way about which I have some doubts: the currency of what I call the community of fate paradigm. The concept community of fate comes from contemporary North American liberal political thought. When political theorists propose that legislatures or other institutions need quotas of women or quotas of African Americans or Latinos or Native Americans, they advocate these constituencies' entitlements to reformed representation by pointing to a history of their non-representation, a history that has caused each to suffer under the hegemony of maleness and whiteness represented as universal. Although advocates of the voice did not use the phrase community of fate, they were at times making this kind of argument, that Indigenous Australians as a whole are entitled to constitutionally guaranteed representation. In their colonised suffering and systematic political marginalisation, Indigenous Australia is conceivable as a community of fate. That sounds right. So why do I want to question the idea that Indigenous Australians can be treated as a community of fate? Understanding Indigenous Australia as a community of fate has certain effects in policy-relevant social science research. I first started to think about this when I read Don Weatherburn's 2014 book, Arresting Incarceration. Weatherburn was critical of an explanation of excessive Indigenous incarceration that depicted Indigenous Australians as collectively caught up in Australia's criminal justice system. Weatherburn pointed out that a significant proportion of Indigenous Australians are never in contact with the criminal justice system. He further pointed out the high rates of Indigenous recidivism. A lot of the Indigenous prison population was churn. That is, people returning to prison after release from prison because they continued to commit crimes. Weatherburn sought to highlight policy-relevant differences within the Indigenous population. In his view, not all Indigenous Australians were living in the social circumstances that make criminal behaviour more likely. Weatherburn was departing from a way of thinking about Australia's colonial history that presents Indigenous Australia as commonly and collectively entangled in the law and order system. He was departing from a narrative of Australia's colonial history that presents the custodial institution as the central and defining instrument of colonial oppression. His approach contrasts with the perspective of critical criminology, in which excessive Indigenous incarceration is the continuation of a settler colonial project to criminalise the dispossessed. Wedderburn argued that policies to reduce incarceration should focus on the social factors that encourage both Indigenous and non-Indigenous people to commit serious crime. He pointed to programs to increase the school leaving age, to reduce unemployment, programs to get people off substance abuse. He urged us to attend to the proximate causes of criminal behaviour, factors common to Indigenous and non-Indigenous offenders. While it is plausible to argue that their colonial history has led Indigenous Australians to be living in these criminogenic circumstances, that is a thought that is of little use to policy. A historical argument that may be true does not necessarily point to the way of effective intervention. I see two weaknesses in the community of fate paradigm. One problem with it is that it tends to generalise across Indigenous Australians and does not use population data to distinguish Indigenous Australians who are flourishing from those who are not. The other questionable feature of the community of fate paradigm is that to the extent that its causal model looks back to historical origins of Indigenous distress, it takes attention away from proximate causes that may well be open to corrective intervention. I now turn to research on Aboriginal health that uses population health data to identify what makes Indigenous people more healthy or less healthy. You may know of the project Mai Kuwayu, the national study of Aboriginal and Torres Strait Islander wellbeing, which is based at the ANU. It has examined the relationship between the practice of Indigenous culture and the health of Indigenous Australians. Their research is guided by a hypothesis that strong culture leads to good health. They may be right. The group's 2017 review of 72 studies published between 1997 and 2017 found positive associations between Indigenous cultural practices and health. The Mai Kuwayu group also found, however, that the studies showing this positive association were not methodologically powerful. Quote, "The strength of available evidence examining the relationship between cultural factors and health for Indigenous peoples is moderate to low." However, their paper ended on a positive note. Despite imperfections in measurement, the research team believes that this review is a valuable contribution to the evidence base and supports and works towards validating the knowledge of Indigenous elders. The Mai Kuwayu project is aligned with the strength-based approach to closing the gaps. Sarah Burke, an anthropologist working with the Mai Kuwayu group, has explained her preference for the strength-based approach. I'll just read her words. "The deficit discourse," she says, "has positioned Aboriginal and Torres Strait Islander peoples, and therefore myself," she is Indigenous, "as second-class citizens in Australia. The personal impact of this cannot be understated, and it is in challenging this discourse and researching how others do so that I am able to regain my agency." Complementary to the work of Mai Kuwayu is epidemiological research that has established a positive association between racism and bad Indigenous health outcomes. According to a systematic review of 463 studies that were published up to 2024, this research program linking racism to bad health has attracted a lot of effort internationally over the last 10 years. However, the review found that this research program had not been able to standardise the independent variable racism, and that, quote, "overwhelmingly, the field continues to focus on direct interpersonal experiences of racism." The review also acknowledged that the research did not identify the causal pathways between racism and what they call health harms. However, the authors of the study were upbeat about the political significance of showing a statistical association between racism and poor health. The 463 reviewed studies are, quote, echoing what First Nations people and people of colour have been saying for centuries. And another quote, by recognising racism as a fundamental and unique social force, end of quote, affecting health, these researchers are, quote, countering false narratives and deficit frames that implicitly or explicitly focus on individual behaviours, limitations of parents or children and young people, end of quote. How useful is research that affirms culture as the basis of good health and racism as the cause of bad health? I am uncertain in my answer to that question. I am more confident in concluding this lecture by making an observation which is really the observation of an intellectual historian rather than a person who knows what to do about policy. And this is my observation. Indigeneity is an object of knowledge that is now produced in a number of different domains of governmentality. In administering the native title system, the state intervenes beneficially, I hope, by producing knowledge of Indigenous Australia as an ensemble of First Nations, each a collective project of social reproduction. However, in other domains of government action, those concerned with closing the gaps, we should not assume such a holistic framing of indigeneity. It may be more revealing to disaggregate the Indigenous population by asking why are some Indigenous Australians flourishing and others not flourishing. My worry is that contemporary social science may be too wary of posing that question. Social scientists may prefer to deal with Indigenous Australia in the holistic frames that are appropriate to the operation of the native title system. I'm pointing to the strong political attraction of the community of fate paradigm, including the quest by epidemiology for further demonstration that Indigenous populations thrive by practicing their culture and are made sick by racism. So that's all.